Legal aid and civil forfeiture. The right to justice. Legal aid is assistance provided to those who cannot afford it. It is often necessary for a defendant during a case. After the decisive court case Gideon v. Wainwright, free legal aid for those who cannot afford it is given automatically to defendants in criminal cases. However, this does not apply to civil cases. Civil cases are lawsuits that deal with contracts or wrongful acts that result in injury or damage. For example, divorces, custody battles, and landlord and tenant matters are all categorized as civil cases. Additionally, civil cases are subject to case filing fees that can often be expensive. This is ethically problematic because it gives wealthy individuals a right that low-income individuals do not have. Because a wealthy individual has the resources to pay for civil court fees and lawyers, they are able to settle civil cases in a court of law. However, low-income individuals do not have this liberty because of the overwhelming cost of court and lawyer fees. These fees discourage low-income individuals from attempting to resolve their disputes, as only 20% of low-income Americans seek help for a civil legal problem. Despite the low amount of civil court cases for low-income people, these civil disputes are often very critical, as homes, families, and financial stability may depend on settling the dispute. Today, America has a group called the Legal Services Corporation, or the LSC, that provides equal access to justice for those with an economic barrier. It is a publicly funded nonprofit corporation created by the United States Congress. According to the LSC, the justice gap differs between civil needs of low-income Americans and resources available to meet them. The percentage of low-income households that have had a civil legal problem in the last year was 71%, while only 20% of low-income Americans seek legal help for a civil legal problem. Overall, 86% of the civil legal problems faced by low-income Americans in a given year receive inadequate or no legal help. The LSC needs to be expanded in order to increase civil legal help to low-income individuals. In order to ensure that all people have access to an equal right to settle a civil dispute, individuals who fall under the poverty line should be provided a lawyer and have civil court fees waived in cases that are critical to a person's quality of life. For example, these could be cases of housing, custody of children, discrimination, or divorce. This protects their rights that would have otherwise been taken away from them if they had no access to the civil courts. The solution we identified allows for more people living in a low-income household to have access to legal aid. The solution also bridges the justice gap, which is the difference between the civil legal needs of low-income Americans and the resources available to meet those needs. A drawback of this solution would be that the expansion of the LSC costs the taxpayers more money. Therefore, it might be difficult to get support for. Also, employing a state-mandated public defender costs money as well. In addition, the state will lose money if court fees are waived. The main drawbacks to our solution is the cost it would take. However, we believe that equality and justice are fundamental rights, and those rights should not be hindered by money. Civil forfeiture is a controversial legal process in which law enforcement officers take assets from persons suspected of involvement with crime or illegal activity without necessarily charging the owners with wrongdoing. For example, in Texas v. One Gold Crucifix, a woman's gold crucifix was taken after a minor traffic offense with no ticket issued and no reported contraband. Even though there are some constitutional safeguards that protect from unnecessary search and seizure, a police officer's suspicion is enough probable cause to conduct a search, since they have experiences to determine if the actions of a person could mean that they are potentially involved in illegal activity. Upon confiscating property, the officer is obligated to issue a waiver that dictates how the property can be returned to the owner. Even though waivers are necessary to retrieve confiscated property, officers often fail to issue them, and uneducated suspects may not know to ask for one. The cash for freedom technique allows the suspect to go free if they simply forfeit their property. Even if a person is innocent, they may be intimidated into signing away their property on the spot, or may not fully understand what they are doing. The money forfeited in this case goes directly to funding law enforcement. Although civil forfeiture can affect all people, its effects weigh heavily on low-income groups. The process itself of retrieving forfeited property may require filing a civil case and legal advice, both which require fees that can add up to thousands of dollars and often more than the confiscated item itself is worth. This presents the obvious challenge that impoverished people would not be able to afford the retrieval process.
Our solution is four-pronged. First, civil forfeiture should be considered a criminal case, which would guarantee that everyone would have access to lawyers and they would not have to pay case filing fees. 87% of federal forfeitures are civil, not criminal, so the government did not have to charge or convict anyone to take their property. Second, we propose implementing the FAIR Act in legislature. This shifts burden of proof to law enforcement and not the suspect, which means the suspect would be considered innocent until proven guilty, instead of the other way around. It also raises standard of proof from preponderance of the evidence, aka more likely than not, to clear and convincing evidence. It would also allow legal representation for poor in civil forfeiture cases. Third, profit incentive, which is the incentive to seize lots of property for profit, should be eliminated. This could be solved by making it so that the money does not go directly to law enforcement. Instead, it could go to education, as an example. Lastly, we want to implement burden of proof, because many people do not get their assets back because it is too difficult to prove that they are innocent. This should be amended so that people are automatically returned their assets if no criminal charge is filed. Our reform to civil forfeiture protects the people's right to their property. It also prevents officers from tricking a suspect into forfeiting their property. The confiscated assets would continue to help the community, however, without the profit incentive for the justice departments. A downside of this reform is that taxpayers would need to continue to finance the fight against crime, as opposed to the money coming from the crimes being put directly into fighting crime. An additional con would be the legal cost for the government. Because we propose making forfeiture cases criminal cases, the government would be obligated to provide lawyers to those who could not afford them, thus making forfeiture cases expensive for the state. The threat of wide-reaching civil forfeiture may discourage people from committing unjust activities, so reducing the extremity of it may lead to more crime.
Although our proposed solution is more expensive to the taxpayers in the state, the benefits of protecting our citizens' rights to their property is a worthy expense and would continue to benefit the community while also providing justice for innocent suspects. As with the case of civil legal help for low-income Americans, protecting citizens' rights should be seen as more important than the cost it may incur.
Thank you for watching. We hoped you learned a lot about legal aid and civil forfeiture.